It's still on state sovereignty, but we're not going to get to the dignity-based account of it.
Okay. So we're going to start with Eric, and then we're going to go to Mohammed, state enforcement of international law to tackle irregular migration in the Indian Ocean. And then we are going to end the presentations with Jose's paper, Policy Transfer Fails, International versus Local Customs, the case of child labor legislation in Bolivia. Do you want to introduce your colleague, and then I'll introduce my colleague?
Okay, my colleague is Ali Agyasi. He's from the Political Science Department at Carleton. I am International Relations. His area of research is political theory. I mean, my school is very policy-oriented, so theory is good, but we are focusing a lot in policy application. So, but he's the policy side. He actually helped me with the theory, so that's good.
Okay. So we've expanded, we've doubled our audience. Thank you guys for coming.
Thank you.
No pressure here, but this is my colleague, Mark Socklaven. He's at Shippensburg State University. He teaches international law. No pressure, guys.
No pressure at all. I'm here to learn.
Eric, take
Okay.
away.
So thank you all for coming. We're going to keep this pretty informal, given it's a little bit of a small group. Full disclosure, I'm a philosopher, but I'm one of these
I would
philosophers.
never have guessed that.
So I'm one of these philosophers who works at the intersection of a whole bunch of disciplines. So I figured it was good to come talk to some political scientists and hopefully someone who does international law about the paradox of state sovereignty. So the question I'm interested in is what I call, and people in philosophy call, international law's existential question. That is international law, properly so called? You're probably all having flashbacks of horror stories of philosophy. But this is an important question because whether or not something's a law, it's the question that turns on it, or the practical thing that turns on that, is whether it's justiciable, right? And before something can be justiciable, we have to identify whether there exists an international legal obligation. So is international law? Well, there's a received view of what makes it law. How do we identify its existence? And the received view would be the consent-based account. We identify the existence of international law insofar, if and only if, a state consents to it, right? So I want to know whether a state's bound by a particular treaty, whether a state has an international legal obligation. I look for some fact about state consent. I want to know whether a state has human rights obligations. I look to whether the state has consented to being bound by those obligations. Right? This is found in the restatement, the third restatement of Foreign Relations Law in the United States. This is also found in the statute of the ICJ. And this is reiterated time and time again, both by judges, philosophers, political theorists, that international law is law. There exists an international legal obligation if and only if states consent. Of course, there are a couple of well-known problems with this. There's some paradigmatic examples that everybody agrees are laws. Everybody agrees are international legal obligations that don't seem to depend on state consent. So the first example is, at the very least, the language of human rights, right? So if you look at the International Covenant on Civil and Political Rights, as well as the International Covenant on Social, Economic, and Cultural Rights, right in the preamble, it's the rights therein derive from the dignity of the human person. Well, that's an odd thing to claim, given that we identify the existence of international law through state consent. And yet these treaties kind of fly into the direct face of that. The human rights therein derive from the dignity of the human person. Similarly, we often see states criticizing other states for failing to abide by human rights, even if they haven't signed on to the treaty. So human rights looks like a little bit of an odd thing to fit under the received view of international law. The second paradigmatic case would be jus cogens norms. So jus cogens norms are articulated in the Vienna Convention on the Law of Treaties. They are both said not to derive from the consent of states, but most importantly are not subject to change through the consent of states. So these two examples would seem to give us some evidence for thinking that state consent is neither necessary nor sufficient for identifying the existence of an international legal obligation. Because we have at least one, definitely jus cogens norms, and two, maybe international human rights law, that don't fit that model. So the problem is, or one way to retort to this, is to say that is for the theorists to dig in their heels, right? So I call this theorist the theory first theorist. So there's a famous line in philosophy, it's like one man's modus ponens is another's modus tollens. So you can imagine the argument going something like this. It's like, if there exists an international legal obligation then that doesn't depend on consent, then that obligation is simply a chimera. It's not a real obligation. It looks like law, it sounds like law, but it's not law. This is kind of like the classic way to defend yourself against the counterexample strategy. You just deny that it's a real counterexample and assert that the theory dictates how we identify law, and insofar as it falls outside of that theory, it can't really be law in the first place. So that's the rebuttal to the counterexample argument. That's what I'm imagining the theory first theorist is going to say. But of course, the theory first theorist is going to have to give me pretty good reasons for thinking why our theory should trump the practice. Again, the theory of international law says X. It all depends on state consent. The practice of international law, the way judges, lawyers, politicians, and others go about practicing it, say like, no, international human rights count, and jus cogens norms definitely count as law. So the theory first theorist is going to have to give me some kind of like overriding or prevailing reason for why we should privilege the theory in this case. So I start going out there and I look for what those reasons might be, what those prevailing reasons might be. The first reason I consider, and like this is on your handouts, is that the reason why we want to stay committed to like the consent-based view, what I'm calling the received view, is because it's a commitment of legal positivism. So legal positivism, like articulated by Hart, says like there are like primary and secondary rules. Of the secondary rules, the most important is the rule of recognition. And insofar as there's a rule of recognition in international law, it's that international law is identified and depends upon state consent. Well, there's a couple problems with this. One, not all lawyers, scholars, and politicians are positivists, let alone positivists of the Hartman variety. And two, there's pretty good evidence out there done by, or in a recent paper written by Samantha Besson, which shows that like legal positivism needn't be committed to this. So we can still be legal positivists and not believe that international law and the identification of international law depends on us recognizing state consent as the thing in which it all bottoms out. So this first like potential prevailing reason I think can be dismissed. It might be an interesting interpretive question, but it's not going to carry the water our theory first theorist needs it to carry in order for us to dismiss the practice. So the second reason, and where kind of like the title of the paper kind of like gets its name, is well, maybe state consent is the necessary foundation in order to avoid the paradox of state sovereignty, right? So the paradox of state sovereignty is like pretty well documented. What's less well documented is that there are essentially two versions of the paradox. There's the external paradox, or the paradox from without, which says that states, being the kinds of things states are with sovereignty, that is, they make the rules for themselves, can't be bound by some external authority. Because if they were bound by some external authority, that external authority would be sovereign, not the state itself, right? So that's the paradox from without. It's like this external authority problem. There's also the paradox from within. This is less well recognized in the literature, but was recently, or kind of recently, articulated by Timothy Endicott, and that's the internal paradox of state sovereignty. And the internal paradox of state sovereignty is not that they can't have some kind of obligation imposed on it from without, but it's kind of parallel to the problem of self-promises. When you make a self-promise, who are you obligated to? How can you be obligated to yourself insofar as you can always relieve that obligation? It seems like that's not obligation in the relevant sense of the word. So how is it that if states have an obligation to abide by international law because they made that obligation upon themselves, how is that a real obligation in any sense of the word? So the general argument, and this is on the second part of your handout, the general argument then is something like this. It's like, if consent-based accounts provide us with an answer to the paradox of state sovereignty, it seems as though the theory first theorist succeeds in providing us with a prevailing reason to continue to endorse the theory despite the fact that it's out of line with the practice. So the question now is, well, does the consent-based theory actually get around these two paradoxes as they're articulated? Can it get around the external paradox, and then can it also get around the internal paradox? So in response to whether it can get around the external paradox, I think Hans Kelsen is a useful place to start, because Hans Kelsen thinks it can, right? So Hans Kelsen says, it's like, look, there's nothing in our law which says like law has to look a certain way, or we can only incorporate these obligations and not others, right? So like law is contingent and malleable in this way. The second step then is to observe, so in order to have like, or in order to get around the external sovereignty paradox, we have one of two directions we can go. One, we can internalize all international law as just being like garden variety state-based law. International law is law like any other. Or we can go from without, which is to subsume all national legal orders into some kind of monastic international legal order. Again, there's no problem of sovereignty there, because what's sovereign is the international legal order. He thinks in both cases this avoids the external sovereignty paradox. So at this point, like coming back to our theory first theorist, it's like, okay, so here are two potential answers. Which way will our theory first theorist go? Well, notably, the theory first theorist can't really go the second direction. And the theory first theorist can't go the second direction because if all national legal orders are subsumed into an international legal order, they've given up the principle that state consent is the foundation upon which all international law is based. Because it's not. It'd be like whatever the international legal order says is the foundation upon which all international law is based. So option two that Kelsen articulates isn't a live option for our theory first theorists digging their heels in. So they seem to be left with option one. Let's make everything look like state-based law. Of course, I think there are a couple problems with this. The first problem is just kind of like observational. It's like, well, it seems like there's a lot of international legal bodies that are displacing or at least pushing downstream the relevance of state consent and the relevance of the national legal order. So like when we look at institutions like the WTO, but we also look at like international or transnational legal institutions, which include things like IATA and the tuna courts in Japan. It seems like increasingly state consent and these legal orders are kind of like working side by side rather than being kind of a unified whole. The second problem, and this is kind of like the more theoretical point, is that while one successfully gets around the external sovereignty paradox, it unsuccessfully gets around the internal paradox, right? So the internal paradox is like, how can a self-promise be binding in any relevant sense word of kind of like obligation or bindingness? So why do I think it can't get around the internal paradox? I think it can't get around the internal paradox because it can't make sense of the following problem. In order for it to have an obligation, in order for state consent to be something which generates an obligation, there would need to be some prior rule that says agreements must be kept. Right? This is Hart's observation in like the concept of law. There needs to be pax servanda, which would need to be at the very least agreement on this fundamental norm. And of course, this isn't available to our theory first theorists because on what basis would there be agreement on that norm? The theory first theorist has to say consent. And then we get this infinite regress of consent like all the way down, and the theory never gets off the ground. So is this a problem just for philosophers, or does it have any practical import? So I think it has practical import along the following lines. And this was my like hobby horse example for a long time, and it finally got some attention just the other day. It seems like one problem that state consent runs into is it can't make sense of withdrawal provisions in modern treaties, right? So if you think of the Paris Accord, as came out in like Politico the other day, there's like a detailed set of withdrawal provisions that says it's like 3 years from the day upon which the treaty is ratified, you can submit a letter. 1 year after that, you can withdraw from the treaty. But in what relevant sense, if it was a self-promise, would you have an obligation to continue to abide by a withdrawal provision after you've withdrawn your consent? Who are you obligated to? Why are you obligated to some past self? It seems like this is a problem in the personal sense. It seems like this problem is just amplified in the context of states. Because not only are states not like biological or like natural persons, states already have this like kind of like aggregation problem, and identifying like what thing is the state over time becomes like a really complex problem. So I have a dignity-based account of state sovereignty, which I try and put forward that gets around these problems. We're not going to get into that. And instead, I want to leave this presentation as like a call for revision. It's that if you can accept that these represent real challenges to the consent-based theory, then at the very least we need to revisit the foundation upon which we identify the existence of international law, and this would have significant import like across the way it's practiced.
Okay. And we're going to talk about that, and one of your points directly relates to Jose's paper. Mohammed, you want to go ahead?
Yeah. Good morning, everyone. 4 years back, in the Indian Ocean region, there has been incidents of massive influx of Rohingya migrants and displacement of minority people in the geographic location of Myanmar. We would see that approximately 500,000 people, they crossed the border of Myanmar, entered into Bangladesh, and then they made effort to cross the Bay of Bengal and other parts of Indian Ocean region to reach some countries like Malaysia, Indonesia, and further south, Australia. When we look at that crisis situation, it may come into one's mind that this situation can be handled easily if the destination countries like Australia or Indonesia, they cordially receive those people who are trying to enter into the country in an unauthorized way. Well, the situation is not that much simple to solve. There are other issues that are connected, like organized criminal activities. Those people are trying to cross the ocean with the help of organized criminal groups who are facilitating human trafficking, which is not a very good or very voluntary initiative to help helpless people. In my paper, I'm not trying to talk about human rights or refugee status of those irregular migrant people. I try to focus on that whether application of international law can mitigate this crisis situation in the Indian Ocean region. Well, my previous presenter talked about application of international law. We see that various international law treaties like Refugee Convention Protocol, 2000 Migration Protocol, these protocols drafting procedure, we see that the states are very cordial to participate in those laws and treaties drafting procedure, but they are not that much friendly when it comes about ratification issue. And we know in international law, if any treaty is not ratified by any sovereign state, then there is no value of application. It means that those international treaty norms are not going to get reflected in the national law and policy of those respective states. Well, if you focus on the coastal states of Indian Ocean region, where those crises has been originating, like Myanmar, Bangladesh, and the transit states like Thailand, Singapore, Malaysia, Indonesia, and again the destination states like Australia. You'd be surprised to observe that actually countries like Australia, they ratified and try to reflect the international law norms in the national law and policy. But if you focus on the constitution, the national legal policies regarding migrants and refugee peoples in Myanmar, Bangladesh, you'll find that the national law is very silent about application of international law. And even if there is any existence of any national law and policy, you'll be surprised that actually those policies are devoid of all international norms related to human rights or humanitarian issues. So the fact is that these non-application of international law norms in those countries actually deteriorating the situation of irregular migration crisis. If you focus on international law about irregular migration, we'll see that especially irregular migration by sea, we'll see that on the prime international law treaty, that is UNCLOS 3, we'll find that there is no mention about irregular migrants issue. There is obviously there is mention about how distressed people can be rescued or the piracy issues. Anyway, indirectly, when we look at the international law treaties, we'll see that irregular migrants can get some help from international law treaties when they are in persecution from their own state and fleeing the country. Yeah, refugee convention will help them because there is a jurisprudence law about non-refoulement principle. It helps them. And again, Article 98 of UNCLOS 3 mentions about how to assist people who are in distressed at sea area. Well, state is a sovereign state, and it has some, it preserves some rights, who to enter into their territory and who not to enter their territory, because security is connected with these issues. And we'll observe that the law enforcement agencies, when they conduct their operations in ocean water, they are actually more concerned about security area. However, when distress incident happens, there's precedent that they try to initiate rescue operations. But you'll be surprised to observe that that soft corner has been exploited by human traffickers. You'll find that in Indian Ocean area, especially borders near Malaysia, Indonesia, there's happened that traffickers use rubber shaft, those small boats to transfer irregular migrants. And they intentionally, what I can say, that submerge those vessels in near territorial water of Ashmore Island or Christian Island, which is very close location to Australian territory. So they intentionally do those incidents to create rescue operations and try to force the countries, like destination countries like Australia, Indonesia. What is happening that due to non-application of international law norms, you will see that these perpetrators who are violating humanitarian law principles and human rights law, they're escape the clutch of both national law and international law provisions due to the simple non-recognition of international law norms by states like Bangladesh, Myanmar, Thailand, and other countries. What I already told about, these have been discussed elaborately in various legal arenas. I'm from political science background. What I did, I conduct some quantitative analysis on that issues, because I observed that when these crisis situations have been discussed with international organizations and those countries from where the crisis has been happening, they're not interested to listen the philosophical words of international law. They are more interested, specifically the security personnel and the national organization we are connected with such disaster issue. They are more interested to listen about the statistics, the criteria. Well, I conducted data analysis. I use counter-trafficking data set. There, I use some variables to find out that how the situation is connected. I used a variable which is the enforcement of law against irregular migrant people. And the independent variable is to restrict their movement, which is connected with non-refoulement principles. The variable which is related to withhold daily basic necessities, which is also connected with some humanitarian norms, and aqua farming. Actually, I use that variable. The reason is that we'll see that in many organized criminal activities, there is a tendency to exploit human traffic victims, to entice them, to lure them, to take this sea route way. And when they are in the middle of transit position, they've been exploited by extortion, forcing them into forced labor and other physical torture issues. That's why I used that aquafarming, because in Thailand, Malaysia, and Indonesia, there has been a record of exploiting people, non-citizen peoples, through engaging them in fishing industry. I have found that there is a significant amount of connection with threat of law enforcement, along with withholding daily necessities and restrict movements. So my analysis actually support the trend that when states do not follow international law, when they threat people who are entering to the country in an not authorized way and were termed as irregular migrants, they have been threatening to restrict their movements, to confine them in camps where there is very limited basic necessities. And all this happens because the countries which are doing this, they are not following international law norms. The significance of my research is that my paper tries to show that this crisis situation, though it cannot be completely solved, but this crisis situation can be mitigated if there has been a pressure from international community and international academia, if they talk about that how international law application, especially the human rights and provisions regarding transnational organized crime activities, they have been ratified by those countries from where the migration crisis is initiated. If they follow those international law norms and reflect those norms in the national law and policy, a sense of responsibility will arise among the law enforcement and the legislatures among those national states, and it will ultimately pose some kind of gatekeeping situations to initiate such crisis. Again, you see the countries from where these migration crisis has been initiated, those countries are not very much friendly about human rights, about democracy, and also about rule of law. So when a country through its constitution reflect the international law norms and apply those into the national law, obviously there's be a sense of respect and compliance attitude towards rule of law, human rights obligations, and also respect to democracies and accountability. It will ultimately put pressure in the state mechanism to be more respectful about compliance of the human dignity and respect rule of law for the sake of human rights. So from that perspective, it is very important, and this is necessity because what we have been observed that when the crisis has been originated, most of the media focused on the functions of some migrant destination states like Australia, how Australia is behaving. What they actually means and what has been overlooked is that why this crisis has been originating, why it has been happening. Is the originating states, like Myanmar, Bangladesh, and other transit countries, they are complying those norms? Why there has not been any activities over there? And again, when this application of international law will come, so we'll find that we'll figure out that how international organizations like UNHCR and United Nations and other regional organizations, how they can play a role in enforcing international law norms in those countries. This has been overlooked. My paper actually, through the quantitative analysis, try to push a kind of emphasis very much indirectly, because it is why it is necessary, because the world is moving, and sometimes it happens that when you talk about human rights and international law application, there's necessity to work with other scholars of other disciplines like international relations, political science, and security studies. And when we try to make a contribution on that stage, we also need to show some kind of data and some kind of statistics. What I've been surprised to observe is that the way we have been investing our scholastic efforts, it had not been reflected at national and regional level. I'm not talking about all national, regional areas. I've been talking about the areas of South Asia region, some specific areas of Asia, where compliance and respect or comprehending the significance of international law has not been understood properly. There is a necessity to make emphasis from various international legal platform to put emphasis on that area. That's all. Thank you all for kind listening.
And then Jose.
Now I understand it's actually
Yes.
very good, full of ideas. So I'm going to apologize because I'm an economist. So the most of my life I work in international development. So I work in the field in Latin America, Africa, and Asia, but mostly in Latin America. So when I'm doing my PhD in international affairs, and I was fascinated by policy transfer. Policy transfer is not something new. It's something that was always happening. However, thanks to globalization, policy transfer now is stronger than ever. It's more easy to do policy transfer because we have access to more information, social media, etc. It's like a mirror. You can see like a live what is happening in different countries. So policy transfer is a way that one environment adopts some ideas, policies, institutions from other countries and try to apply to their own environments. I was very interested in the case of Bolivia because I'm also a child labor researcher, so in order for me to find a good case of policy transfer, good case for my research, because when I was doing my research on all the studies on policy transfer, the most of them are made in the North. So the most of them talk about policy transfer in the UK, Norway, United States, etc., but there is not much about policy transfer in the South. And that is why the most of the literature says that policy transfer is good. It's a way to innovate policies. But that is why, because they didn't do much research in the South. So the idea of my paper is like not all the policy transfer is as good as the research says. There are some components that have to be taken in count in order for a policy transfer to be successful. Okay? So why policy transfer? So why emerge policy transfer? So policy transfer generally responds to three types of policy problems. For example, transboundary problems. We can say like smuggling, trafficking, money laundering, etc., etc. It also responds to common property problems, for example, borders, ocean management, like we have dispute between Nicaragua and Colombia for the border, like Chile and Peru for the sea, etc., etc. Even rise over Antarctica. And also because there are simultaneous problems. For example, if we talk about South America, so there are common problems of poverty and education. If we go to Africa, different countries have different problems on health, gender, etc., etc. But I just want to quote the most known definition of policy transfer. So policy transfer is a process which knowledge about policies, administrative arrangement, institutions, and ideas in one political setting is used in the development of policies, administrative arrangements, institutions, and ideas in another political setting. Okay? This is not a static process. It's not that I copy, paste, no. Policy transfer takes time. So it could be done in time. It could be done like a soft, or it could be done very hard. But that is the main idea of policy transfer. So policy transfer is to have a model and try to copy to my environment. Why people say that policy transfer is good, is innovative? Because, of course, if I see something outside, I have the idea, I can apply that to my own environment, making it better. So that is the idea that we have on policy transfer. What are the mechanisms for policy transfer? Like the literature says that there are 4 mechanisms. The first one is learning. That means that a country has the rational decision to check another environment, to see the problems, to see how they solve, and try to bring that to their own environment. Okay, it's a learning process. Okay, he's making a mistake, I'm gonna do it better. Okay? Another way of do policy transfer is competition. And this is very common in developing countries. For example, I am Peru, my colleague is from Chile, so I want investment. So I can work in my policy, in my national policies in order to attract investment. For example, less taxes, privatization, etc., etc. Sometimes competition could be pervasive because some competition has led to, for example, the relaxation of labor laws. That's happened in different countries, but whatever. Competition is a way in which countries, they do policy transfer. Another mechanism is coercion. So coercion is also something that is mostly for developing countries. It is, the classic example of coercion is when the IMF or the World Bank goes to the South, goes to Africa, and they say, okay, so if you want my money, you have to apply all these policies. If not, it's no deal, okay? And it's interesting because the most of the literature says that coercion is not one of the main mechanisms for policy transfer. However, if we think about global South, about developing countries, my guess is, my big guess is that coercion is actually one of the most used ways to do policy transfer in the global South. And the last mechanism for global for policy transfer is mimicry. It's just to mimic something. For example, there is a country that is very cool. For example, I don't know, the UK, France, Canada. So as a country, I want to copy exactly what they are doing in order to look good. Or for example, there is an international organization that is doing something very, very important in human rights. Oh, I'm gonna take that because I want to look good in the international arena. Okay? So, as I said, but policy transfer can have some problem if it's not done properly. For example, what can make policy transfer to fail? When we do, for example, uninformed policy transfer. So it is like one country has a complete idea of what is transferring. Okay, they don't have the full knowledge. That could be related to mimicry because they think it's good, but they actually don't have the full knowledge of how to apply to their own country. Another failure, according to the literature, is incomplete transfer. Maybe they transfer some ideas, some policies, etc., but they didn't transfer the key components. For example, maybe they didn't realize that the country that they are copying, it has a very strong institutions. But my country doesn't have it, so I'm missing one key component. And the last one, leading to failure, generally, is the inappropriate transfer, where the policy transfer is done without consulting stakeholders in the local environment, in the local country. For example, if I'm doing policies on education and I don't consult the stakeholders in my own country, it could be a clash. Because maybe the policy that I'm transferring is actually only working in some environment, but not in my environment. It doesn't fit even my cultural values. Okay? That is policy transfer. Now I'm going to talk a little about child labor. I mean, child labor is a topic that is very hot. Everybody, when we hear child labor, we picture people in Latin America, people in Africa working in cocoa plantations, in cotton, rice, so under very bad conditions. I want to be clear that child labor is not only in developing countries, and it is not new. So in the 90s, like the US, in 1900, like 30% of the children between 10 and 14-year-olds, they were child labor. Okay, and why? Because it was more easy to work with them, and because of course they could be exploited. So in Europe, for example, right, we cannot imagine now that Europe could have child labor. Okay, I'm not going to talk about Bosnia or those countries, but we don't picture child labor in Europe. But Europe was also, they have a very, like a big, they have a strong, like a child labor force in the 19th too. Okay, so this is not a new phenomenon. So this has happened before. So it is not a problem just for developing countries. Okay. When we talk about legislation, so in child labor we have two like a major organizations who deal with child labor. We the fight against child labor. One is the ILO, the International Labour Organization, that was created in 1919. And then we have UNICEF, that is a body from the United Nations that was created in 1946. The ILO is mostly oriented to legislation. So it is an international organization who is the leader in the legislation about child labor. And actually the idea of the ILO, the goal of the ILO is the eradication of child labor. UNICEF is mostly more about protecting the rights of the children. So, but what is child labor? So child labor is any kind of work that is harmful for the children, that is dangerous, physically and morally dangerous, and interfere with schooling. So that is what we define child labor, and that is the way that ILO defines child labor. However, it is also important to notice that not all forms of child labor are bad. And in that sense, the ILO and UNICEF, they agree that not all the forms of child labor are bad. So when I was a child, for example, so I grew up in a farm in northern Peru. So I helped my family. So when I was 5 years old, after my school, I had to run to my farm, having a BB gun, and kill the birds because they were eating my rice. I never felt exploited, and I was not exploited. I was helping my family, and I finished my education, and I have good grades, awesome. But I just want to be careful because that is very important to notice. Not all the work done by children is child labor. I don't tell to your children, you don't have to clean the house, that's child labor, come on, right? So it is very clear, and we all agree with that. However, what is child labor? What is family labor? Is passive. That creates a huge problem internationally, and sadly, the ILO, I don't know if in purpose or what, so they are still having some problems in exactly define what is family labor and what is child labor. But anyway, two important resolutions from the ILO. So the ILO has, in 1973, they have the Convention 1380. That convention is very important because it established the minimum age for work, that is 14 years. And that was kind of taken for all the international community. That was the rule. So that was the rule of child labor. So children should not work if they are younger than 14-year-old, okay? And something that was stronger is like in 1999, they passed the Convention 182, where they focused on the elimination of the worst forms of child labor. That is slavery, etc., etc. Some people consider prostitution, but I don't like that, because prostitution is not child labor, it's a crime. And it shouldn't be considered as child labor. Prostitution of children is such as, right? It is a crime. So the ILO has working very hard in the elimination and eradication of child labor. It's part of their mandate, part of their goal. And it's actually including in the SDGs. One of the SDGs is the elimination of the child labor. And that has been the work that the ILO has done. However, when we talk about legislation, we have to talk about definitions, right? For the ILO, so children have human rights, of course, because they also have rights, but according to the ILO, is for the best interest of the rights of the children to take them from play. That is the ILO vision. However, in academia, especially academia in the Global South, there is a huge conflict between, in some ways, the North defines a child like a super helpless, sometimes useful. When in the South, culturally, they have an idea of what a child can do. I'm not saying which one is better than the other. I'm just saying those are the two ideas that we have in the world, right? So, and there is always some critiques, as usual, that anything that is done in the North doesn't take into account whatever is happening in the South. Even the definition of poverty was done in the North. Have you ever asked a poor guy how can he define poverty? You will be amazed about his answer, because it's not exactly what we think is poverty. Okay? So going to the case of Bolivia, because I was working in Bolivia when I was young, so it is very interesting. So child labor is very strong in Bolivia. There are many reasons for child labor. Some researchers agree or not, but whatever. So the reasons are economic. So Bolivia is a very poor country. Like 40% of the population is under the line of extreme poverty. And worse than that, more than 60% of the population, if we go to rural communities, more than 60% of the population is poor. So there is a big pressure in a family livelihood to have some income. That is why, so some cases, children have to work in order to increase the income of the family, okay? Infrastructure. Even if you want to send children to a school, so sometimes they don't have a school. So when I was a child, I have to walk 2 hours one way to the nearest school from my farm. So 2 hours. One way, and then 2 hours went back. So it is not easy to find a school. And even if you find a good school, a public school, sometimes they don't have windows, they don't have chairs, even the teachers are not going because nobody wants to work in rural environments, so etc., etc. So the infrastructure is more strong in private schools, so that is keeping like the circle of poverty. Since you are poor, you only can go to public school, that is bad. And rich people can attend private schools that are good, so they keep rich forever, okay? And something very important for this case is cultural. So in the Andes, child labor is a tradition. It's something that is very strong, deep root in Andean communities. So they believe that child labor is a path from children to adulthood, because it's gonna teach you very important skills. It's gonna teach you how important it is to work in order to get something, right? It's even teach you some trades. That is why cultural thing is very important when we are talking about child labor. Again, the definition of child labor is different according to where you are. In rural communities, it's something that is tolerated and sometimes even well seen. Oh my God, your children is helping, that is awesome. Now he's going to understand what's the idea of hard work, right? But if you go to Norway, I bet that's not going to be the case. So, so going back to legislation, Bolivia was, he signed all the agreements of the ILO. Because again, Bolivia, same as other countries, they want to see, they want to be seen like, okay, we agree with all the international legislation, so we are a model country, etc., etc. So they ratify all the conventions of the ILO. However, for the last years, so Bolivia was governed by a small elite. That elite is the one who had money to go to Chicago, to go to Harvard, to go to Oxford, etc., etc., and they try to apply those policies that they learned in Europe and America to Bolivia, right? So, and that happened many times. So the people in Bolivia, they always felt that they were never represented for their government. Okay, there was always big clashes between the government and actually the people. And we also have to consider that Bolivia has a very big percentage of indigenous people, okay, that was not represented in the government. They felt they were second-class citizens, okay? But then, Evo Morales happened to Bolivia. So Evo Morales was coming from the social movements in Bolivia, right? An indigenous person. Evo Morales is Aymara tribe in Bolivia. So he came with the idea of having more representation to the people who were underrepresented, and I mean indigenous people, okay? So one of the things that he did was to change the constitution of Bolivia. So, and he included many articles about child labor. Why? Because Evo Morales was also a child laborer when he was a child. He had, many times he has said that child labor is good. When he was a child, he was a herder of, llamas and alpacas, so it was his job, and he's very pro child labor. Again, I'm talking about a work that is not harmful. I'm not talking about, working on mines, etc., okay? So he made a huge change in Bolivia when he passed the law reducing the age for work to 10 years. And something that is also very important in Bolivia was that it's the first time that I see this in my life, there was a union that represented child laborers. So I never seen that in another environment. I don't know if there are now in different places, but Bolivia has a union of child workers, okay? And they were doing a big lobby, and they were saying that denying the right to work is against human rights. They even went to Geneva to expose this case. I think it was very interesting. So, of course, this created like a big, like an earthquake in oh my God, I lost it. So, yeah.
Went to Geneva.
Yeah, no, so this created a big debate in international, in the international arena, right? What are you doing? What you're doing that? You are going against the ILO, so you don't care about children, etc., etc. But for some people, what was done by Bolivia was awesome. You are finally taking in count people who is actually the subject of the law. You are consulting them. However, that happiness didn't last long, because even though the ILO has no power to enforce the legislation that they do, the United States and the European Union, they have some ways to do it. For example, the President of the United States, he said that he's going to cut international aid to Bolivia if they don't change that law. And the European Union also said, if you don't change that law, we are cutting all the international aid, etc., etc. So that's pure coercion. So last year in December, so Bolivia has to pass back the law that takes the child labor minimum age to 14. So in conclusion, I really believe that policy transfer could be good, but we have to take into account local environments, local realities, and coercion could be very harmful, because there is no study available that demonstrates that banning child labor is actually helping to reduce child labor. Thank you so much. Sorry for that.
So you see, we have what I think makes a pretty good panel, starting from this very broad philosophical or theoretical perspective on, do we have international law, and then application regional, and then case study with Bolivia. So I'm going to start with Eric's paper on the theoretical background, state sovereignty, and that's because of limited time. We didn't get to the state sovereignty part. We got to the philosophical background on, and I like that, you talked, it made so much sense when you told me you were a philosopher. That existential thing, do we really have international law? And that's an interesting question. I mean, the first time I ever taught international law, the student said it doesn't exist. and that was because people violate it, and so it doesn't exist, which means we don't have any laws, right? But it is a valid question. I mean, do we have it, and at what point, in your example about withdrawing from a treaty, I think is very relevant in looking at that. This kind of goes back to, I guess, the sources, as we talk about sources of international law. Is it the treaty stuff where you have this absolute consent, or is it customary law? Does it evolve over time? And so something I would say for actually all three papers is, and this, I'm old school, I really like an introduction that gives context for what you're talking about. So why is this relevant for all of the papers? What is it? And this is a hugely relevant question, especially as the U.S. is withdrawing from the Paris Treaty and all of these other things. We did from Iran and probably all of them. So as we keep going. So when, and your question about whether or not, can today's self argue with yesterday's self, we're going to do this treaty, no we're not. Do we have to go through that whole process? So the context of this argument is really, really there. And your state sovereignty part is something that people have been, that's, I think, is coming back, people arguing state sovereignty, and, globalization has made it less relevant, and I think we see states trying to hold on to dear life for that. And so maybe a little bit of a focus on the context, why it's such a relevant topic would help. Maybe, then a little background, and this comes from the political science, but on the sources is, what kind of international law? Does it matter if it's, this consensual law that you talk about is, where it comes from treaties and covenants, or kind of imposed, if you want to navigate our rivers, you have to do it this way, that customary law, and so are we having that clash? Okay, and then the only other thing I wrote down is you make your case here, I think, in your introduction for the relevance of your paper. But the other papers show us how relevant your question is. And so we have Mohammed's paper, which I only received a preliminary rough draft, so I didn't get of what he talked about. And in talking about this, again, I like a theoretical beginning. I want context. I want to see theory as to where it's coming from. And there is a lot of, and we saw it in Eric's paper, when states don't follow international norms, one of these mechanisms, whether it's coercion or mimicry, these kinds of things to get them to do it, what happens in that case? And we see in the case that you're talking about kind of just a big hot mess in the Indian Ocean, with what to do with the migrants and how to regulate, how to disperse, how to deal with the migration that's going there. So I would like to see it couched a little bit more in theory so that we kind of know the direction, and I think theory helps us to evaluate the data and the arguments that you're making there. And then Jose's paper. I really like this. I liked all of them. And you're right. So we have a philosopher, a political scientist, and an economist, which is a perfect panel. And so here we're looking at the case of child labor. And so we've gone from this broad to a regional to a case study. And I'm a political scientist, so I want to see this couched in the theory, which you have the policy stuff in there. But then the next thing that one of the things that intrigued me all the way through as you're talking about Bolivia, and then kind of saying, you know, India was at this level and the UK was at this level. When the UK began to change its rules, and against child labor, is that where Bolivia is now? So in the 1860s, is the level of development for the UK kind of where Bolivia is now? Because I think that all states kind of go through, stages of development. I'm not a subscriber to Rostow, but I think that we can talk about stages of development where, and the United States and Great Britain and all countries, everybody in a rural society, they work on farms. And at what point do we go from working on the farm, and that's fine, to you shouldn't have your child working under the age of 14? Is it a certain level of development or level of comfortability, however you want to measure that, in a society that kind of leads them to go in that direction? And so I guess I am looking at it more in the comparative sense, because I think that you have some ways that you can go in that direction. I also asked, and he didn't get to talk about the abolitionist and the protectionist categories, but can you find and divide countries into the abolitionist school and the protectionist school, and then look at their development, and what can you surmise from that, and how does it meet up with the literature on that? Those are just my general comments. You all can respond. We can open it to our colleagues in the audience for questions and conversation.
I don't know if either of you want to respond. I'm happy to open it. I'm going to not respond at the moment and open it up.
I have one question to Eric, is that well, if you see in various committee of international organizations like UN, you see in its United Nations Human Rights Council, you see the members of those council, they're not that much friendly to international law norms, but still they are able to become member, like Venezuela, like Brazil. So do you think that international organizations, through its placing of country members in various of its committees, it can play some kind of role to change the attitude of states towards international law, to make them more compliant, that if you comply international law norms, you would have some privileged place in those committees?
So this is where people stop liking me. Compliance and law come apart for me in a pretty robust way, at least compliance in the identification of law. Why? Because people fail to comply all the time. That doesn't mean that a law...
Not in international law. Not in international law. Chase and Chase points out, international law is complied with 97 to 99% of the time.
So I'm not denying that there's compliance in international law. It's just compliance isn't a necessary condition in order to identify the existence of law, right? Because some people turn to the existence of some violations, and you're right to point out that actually, for the most part, it is complied with. So don't cherry pick cases on me. Right. My comeback is like, even if you want to cherry pick cases, it's like your standard, like kind of like the theory first theorist, would be so high that you would deny the existence of all law. And you see this time and time again when you run the counterexample strategy, and it's like, yeah, you can embrace that, but you would have to have pretty good reason to do it, and I don't think that reason exists. So one, they come apart. Two, I think my proposal is to shift. We got to get away from like this improper understanding at like the theoretical level, because what we see is judges routinely relying on this consent-based framework for whether or not they consider a particular case to be justiciable. and they look for state consent, or they look for the existence of customary international law, which requires both state practice but also opinio juris, which can be a stand-in for state consent at the very least. And I think if we get the relevant actors to appreciate that that's not the proper test. That's not the proper test for whether a state has an international legal obligation. We can start shifting the conversation in a relevant way. Whether we want to remake the committees or not, that might be too far downstream from anything I have to say.
And regarding Joseph's paper, I agree that some countries are showing that they are complying with various ILO norms, like that age restriction issues. I'm from South Asia region. I visited India, Nepal, and I'm from Bangladesh. I've observed that in some specific industries like textile and tobacco, there's been tendency to employ juveniles who are below 14 years of age, but somehow the owners get some kind of certificate from physicians that certifying that they are above 14 years of age. So my question is, do you think that ILO or the watchdog who are observing the compliance issues of various labor-related international law instruments, do you think there should be some kind of involvement of scientific apparatus with those issues, specifically age-related and health and hygiene issues related to juvenile moms? Because we see in Bangladesh and in India that juvenile moms, they are working hard 16 hours, 18 hours a day in the textile industries. But there is no concern. There is just concern, there is hygiene because there is a washroom. There is no concern about the other health and physical facilities. So do you think that involvement of any technical scientific association with ILO would help us to comply and actually force various countries to really follow the international level laws?
Actually, yes. Let me tell you, Bangladesh is a very interesting case because it's very well studied. And to be honest, something that is very important to consider is about enforcement. Okay? You have international legislation. How can you enforce that? For example, you're just saying they have like a fake, like a health, something that says, oh, this child is 14, it's not 10. You know what? There is a huge problem. And you cannot go everywhere. And to be honest, the case of Bangladesh is very interesting because, for example, the US banned imports of textile from Bangladesh in order to help that industry to eliminate child labor. It has a first impact. Yes, the numbers reduce. However, the child labor transferred to a different industry. So we have to recognize that there is child labor. There are 70 years with the legislation, and it is child labor. So we cannot close our eyes and believe that this is not happening. Why don't protect them? Why I cannot protect them? Why I cannot assume that, okay, there are children working, so are they being exploited or not? Because when you have banning of those kind of practices, so sometimes it generates more child labor. Because now as an employer, I can pay less because it's banned, right? So I'm making you a favor because I'm not tackling poverty. I'm just tackling labor. So now it's cheap for me to hire that child, because since it's banned, I'm sorry, it's a risk for me. I'm gonna pay you less, and less, and less, and less. I wish there would be mechanisms to protect, but that should be something like a work together between governments and international organizations. But my point is we really have to take in account the realities. Don't close your eyes at child labor. It is there. It's looking at you every day on the streets. Protect them, not ban them. So that's my opinion.
I'll see you are first, and where are you from?
My name is Brian Cruz. I'm from the University of Central Florida. I'm a current undergrad student, and this is really, I want to say, since I'm technically international relations track for my political science degree, but I'm also very interested in philosophy. So the first paper is what I want to talk about the most. But I have a few. First of all, I want to say I hate long-winded questions, and I hate to ask this, but there's so much I want to ask. I agree with your assessment that we have a flawed philosophical understanding of the foundation of like, international law and states, authority and stuff like that. But I want to bring up this kind of question because you brought up the paradox of self-governance, right, or self-limitation. In that, who are you beholden to? But I think if we define that international or states are not beholden to international communities, otherwise they wouldn't be sovereign, then we also have to question, but states limit themselves all the time with civil liberties and rights. We have the foundation of popular sovereignty where states have to limit themselves to oppressing individuals. And so if we have that conception and we still believe that states are sovereign, then why couldn't we apply that upwards even further, right? I think we have it's a shame because like sovereignty has been used throughout multiple times with like pretty consistent definition. But I think the definition of sovereignty is flawed because the supreme authority is almost never truly there. The United States is the supreme authority, but it is beholden to people. So is it sovereign or not? And other nations as well. So I don't know. I feel like there's no true sovereignty, and we're working on this very idealistic view of what sovereignty is, and that's limiting our capacity to extrapolate that further.
Yeah. So you're hitting on the exact right thing. It's like the paradox of state sovereignty exists in international law, but we can also go down a level. What exactly it would mean to be sovereign, and like how we get things like constitutional democracies. It's like it's a very complicated story as well, and it's not one that's wholly worked out. So part of the problem in international law is a problem that I identify as like a problem with people have mistook just how many tools we have in doing conceptual analysis. So conceptual analysis, the way Hans Kelsen proposes, is like, look, sovereignty isn't something like chair, right? Sovereignty is an abstract concept. Therefore, like, no matter how hard I look at the world, I can't tell you anything about like what sovereignty is. And I go like, that would be like a really depraved understanding of conceptual analysis, because according to Kelsen, like what sovereignty is, we just go ask people in the community, and whatever they say it is what it is. And this is how we end up with like this absolute conception of state sovereignty, which of course we know at the domestic level didn't work out to give us a foundation for a domestic law, so why would we think this would work out to give us a foundation of international law? But it's just kind of like it hasn't been paid attention to. So one of my points in the full version of the paper is that we need to move away from conceptual analysis in kind of like this defunct way to conceptual role analysis. So we look at the role that sovereignty plays. It seems to protect some sphere of private authority for states. But we can also look at sovereignty as a general term. So for instance, the law of foreign sovereign immunity also relies on a conception of sovereignty, and we've seen considerable development on the law of foreign sovereign immunity. We've gone from an absolute theory of foreign sovereign immunity to a restrictive theory of foreign sovereign immunity. And when we look at those cases and the reasons we're giving, they're much the reasons like, well, it's some relation that states have to people. What relation exactly that is? There are people who go with like a constitutive account. I think there are problems with that insofar as not all states are constitutive in the relevant sense. It sets the bar too high. So authoritarian states no longer have international legal obligations. They no longer have international legal rights either, but they wouldn't have obligations, and that seems problematic. Then you have people like Endicott who go for like, let's see if we can get it off its own bat, like let's go with an autonomy-based view. But then it seems like there's no clear distinction between like why states would have sovereignty and not things like corporations. So Endicott has to kind of retreat back into a constituency view. And then I go, it's like, well, it looked like an improvement, but you have all the same problems. So in the full version, I offer like an alternative, but you're hitting at exactly the right thing. And the call for revision is basically like, let's just appreciate how deep this problem is, and that we're going to have to just admit that it bottoms out in something else and build from there.
I'm Hannah Konowski. I'm also from the University of Central Florida.
Sorry, what was your name?
Hannah Konowski. I also wanted to ask you about your paper because this is what we study and we're very interested in this. I know that you kind of touched on the concept of agency pretty briefly. I guess my question is, do you think that the person or persons acting on behalf of the state impacts the way that we conceptualize this concept of state consent? Because the state is not consenting. Somebody consents on behalf of the state. So how can we maintain state consent as a necessary condition if it's not the state that's consenting?
So I'm going to take this as a friendly comment insofar as, like, yeah, it seems problematic for us to think about, like, how a state can consent in the first place. So, like, why would we start on such shaky grounds? To give, like, a little pushback on behalf of this, because importantly, I don't want to say that state consent isn't relevant in any cases, but it's not the thing that grounds it. In fact, we need to appeal to some kind of other norm or principle which helps us define the areas in which state consent is important, right? Because I don't think it's the case that we can just throw it out altogether. It is important in certain areas, it's not important in others. Jus cogens norms and maybe some human rights law being examples of that, as well as like agreements must be kept, like type foundational principles. So what I would say is, like, I kind of want to be a pragmatist here. It's like, you know, there is a sense in which we can talk about aggregate agents and abstract entities. And there is a sense in which we can talk about someone acting like as a stand-in, acting on behalf of the state. They aren't the state. Like, that would be like the absolute conception of like foreign sovereign immunity, where like the king just like was the state. But there is a relevant sense in which we can talk about, it's like in their role, they are acting on behalf of the state. That doesn't mean that the president or Congress or whomever in a given system is the state, because they still have bodies, they are still persons. And we can distinguish between actions they are taking on behalf of the state and actions that they are performing like in their role. And this is exactly how we see this worked out in the law of foreign sovereign immunity. You have immunity when you're acting in a certain kind of capacity, when you're performing actions which are unique to the state, rather than actions that are personal, right? So if Justin Trudeau comes down here and he murders, I don't know, an American citizen, Justin Trudeau can't claim sovereign immunity because that's like a private action.
Or the wife of a diplomat gets a kid on a bike.
Yeah. Mind you, there are any number of actions that Justin Trudeau can like take, like on behalf of the state, where he would be protected. So what's relevant to thinking about it then, and again, like my push for, we need to understand that we have more tools for doing conceptual analysis than just what people say it is. Let's think about the role the concept is playing, thinking about what kinds of things it's protected, and also thinking about the foundations for that concept. In my answer to Brian, it's like, it seems to me that most people agree that the foundations for sovereignty have something to do with the relationship states are in with people. I think it has to do with the fact that they're in compelled relationships with people, or people are in compelled relationships with states. And this gives them a kind of special status that needs to be preserved.
Can I just comment? Are you sure you're a philosopher? Because you're talking about pragmatism and it's throwing me off.
You know, we're in the States where pragmatic philosophy kind of like got its roots. Yeah.
So I think the judge of a panel did it make me think, and congratulations to all of you for making me think about a lot of things. I guess I have some general comments for all three of you with some examples to kind of have you think about. And I would take them in reverse order. First of all, I wanted to say that I think international law reflects the interests of the powerful. And just as any legal system does, right? It reflects the interests of the powerful. I'll come back to my kind of conception of international law at the end, but I was thinking about this, and I completely agree. The one thing I would kind of, question, and it's probably in your paper, and is that when I think about child labor and I think about the ILO things, I always think about the word remunerative, right? And that they're really tackling remunerative. So you working on the farm, me working in the household, washing dishes, you know, those were things that we didn't get paid for. That was part of the family unit. And I think international law has typically kind of focused on that remunerative aspect. But I would ask you to think about kind of the reflection of the interest of the powerful here. And that is, you know, isn't it interesting that we don't, because in a society, if we talk about that stages of economic growth, which with Cuba, I'm not sure I buy, but isn't it interesting that in a developed society like the United States, education is hugely important for the well-being of a person down the road. And yet, there's no child labor laws preventing a 16-year-old from working in the most dangerous industry in America, which is fast food, right? And so, look, you know, I think it's really interesting that we as you quite rightly point out, is that the United States imposes these things on other people, but we don't, those are in the interest of our society, of which we get cheap burgers at McDonald's because we can make 16-year-olds pay for them there. And so, just something to think about. And Mohammed, I completely agree with your analysis on UNCLOS, and it doesn't deal with migration issues well at all. And this would, this is leading to my kind of conception of international law as I can see it today. Frankly, UNCLOS and international law in general does not deal with migration issues as they stand today, right? We're still built on a no-to-bomb case notion that people go and they get citizenship someplace else. And we know the vast majority of migration, whether it's irregular, because of refugees, or if it's just simply economic migration, most people today are not going to a destination country to become a citizen of that country. And international law does not reflect that at all, right? But yet we're stuck in a mode to do that. And so I think you're right to kind of bring that up. But I think that goes in a larger context about how international law, as reflective as most legal systems are reactionary and not proactive in terms of that. So just something to think about. And Eric, here's where the practical side of me teaching a class comes in. And every year when I'm teaching my international law class, I cringe as I kind of go up. In 1648, we had sovereignty, right? And then, in this myth, I never talk about 1555 or any of those, years. We put it at 1648. And so I see international law as a convenient fiction, right? It's a fictive history that people reflect back on because really the roots of sovereignty and of anarchy are so complex that the average person really needs, Henry Sprunk's 8-year work to figure out what the state is, much less. And so that the international legal system is a reflection on this. And really, when I come down to it, is that I feel like Coop's going to glare at me when I say this, but it really comes down to Alexander Bennett's question about anarchy is what states make of it, right? And sovereignty is what states make of it. And I might qualify that by it's what powerful states make of it, and that I don't dismiss your kind of active endeavors here, but in a practical level, I'm sure most people litigating, most judges don't sit around and think, well, what is this, right? Because they have to deal with what the construction of the international system is today. So I guess one thing I do question on your paper and your analysis is that I think you really pick out, or at least your example was the really weak point in international law. Because the strength of international law is that it's voluntary, but it's also reciprocal. So if Canada breaks it, we're going to break it right back. And we don't need anybody else involved, and that consent plays into that. So by picking out, the environment or human rights, those are the least reciprocal norms that we apply on each other, that these entities apply on each other. And so, that is admittedly the weak part of it. But as Mohammed points out, the environmental, the movement of people, the growth area in international law, where frankly the politicians and the states just haven't caught up with this. I'm not sure that I would want to hang my hat on where the new problems are coming up, and there has been no way to kind of compel states to acknowledge these obligations. I guess I'm not dismissing. I like the paper, and I thought it really made me think. But that would be if I were the reviewer on the paper. I'd be like, can't you find a better example than this? Because this is really questionable kind of stuff.
One of the things that I think that Marion kind of 3 points here is Mohammed's question is how do you get these countries to do this stuff?
Yeah.
And it's the reciprocity thing. When the powers, because state sovereignty is all about the most powerful, when the most powerful countries are vested, you see more compliance. You see, let's address the environmental issues. Let's address migration. Let's address these other things. And then in periods like today, where we don't have leaders leading, we kind of see it falling apart, and we think, oh, sovereignty, man, it sucks. And that part is true as well. And so it comes with what is it that makes countries function in the global system? You're Canadian. We all wish we were Canadian.
But I also want to point out, there's a technical flaw, too. And this could be just in your top. Keep in mind, the Paris Agreement is not a treaty. It never went through the ratification processes, right? And that I would go back to Putnam's two-level game, that what's happening there is that, particularly Obama is looking at his end of his administration on the horizon, trying to figure out how to tie his predecessor to these obligations that he thinks is really important, and comes up with a weird thing in which, and that's what this 3-year period is. I don't think Obama sat down and was like, well, I'm trying to think about the nature of law. I'm trying to tie my future successors, and that's what we see in human rights law. Because my own dissertation was on who ratifies human rights laws, and you would think it's all these liberal states. It's not. It's emerging democracies trying to tie their successors to obligations that they're going to have to meet in the future. And
it's Obama's long game.
It is Obama's long game, and it's kind of going to work, right? If we think that Trump is going to not win re-election, which I'm assuming is, I don't think that he knew that it was going to come out, but just in case, it takes effect the day after the U.S.'s next election, and so it's really practical and not philosophic on a lot of levels.
So I'll let my colleagues answer their questions.
Yeah, and I'm here all weekend if you want to talk.
The power aspect is very important. So when we talk about if there is international law, if we go to something more local, for example, in the South, in the global South, many people says law is only for rich people because there are many people on jails just waiting for the paperwork because they don't have money to push it harder or to make it faster. I think in the international arena, we have some similarities going up to top because, for example, if Russia invades Crimea, if China has like a concentration camps in Xinjiang, human rights violations, right, etc., etc. But if Iran or Iraq invades Kuwait, like everybody, or if Bolivia does something like all the international, European Union, United States, etc., so there is an imbalance, and that's power.
Yeah.
That's actually power. It's a very good suggestion. Thank you so much.
I would like to say that regional scholars and academicians, they should be more proactive regarding the successful application of international law. Because if you see that South Asia region or some parts of Asia, specifically in China, China has had one international dispute with Philippines. We didn't see much participation of Chinese scholars regarding application of international. And again, in that Indian Ocean region, regarding that crisis. The scholars who are belonging to South Asia region and Southeast Asia region, they're not that much active on academic participation in international. I think if they become more active, the application and the future implementation of international law norm become more practical in that region. That's my guess, and I'm hopeful about it.
No, right. So you understand? I mean, yeah. I guess what I worry about is that until you get big powers on, and look at the case of China. The United States has stopped paying attention to what's happening in South China Sea, and the power that is there gets to dictate what that problem looks like.
Yeah, if I have time, I'll offer a couple of brief responses.
Sure.
Yeah.
I can stay here.
Yeah. No. Maybe
I
a
do
couple.
want to invite everybody to the luncheon.
Luncheon,
Yeah, at noon. It's free, graduate students.
Excellent.
Well, you paid for it in your. You paid for
Don't tell me
it's
that
not
now.
free. You paid for it.
Feels like a free lunch.
It's in the Franklin.
Yeah. No. So the first part, and this is probably where being Canadian and not a law student, I'm a little bit out of my depth. But I thought the Paris Agreement was ratified through the executive. So while it's not like an Article 2 treaty, it was still.
Yeah, that's very fuzzy.
Okay.
That's very fuzzy.
So it's fuzzy. So it's fuzzy, but I've certainly talked with some lawyers and like Obama era lawyers who were defending that this was a fine way to make a treaty, and in fact there's like trade agreements that were based like on the same type of ratification process. So I would push back a little bit, but not too much because I'm out of my depth. The second thing is the broader point is that it just doesn't make sense of withdrawal provisions within any modern treaties. So it's not just about the Paris Accord.
I don't know. I don't know. I mean, but I'm sorry to interrupt.
And then probably the last part to kind of like address like your realism type challenge is like, one, I'm first and foremost a minimalist about law, and particularly so it's like I direct my work toward judges more than anybody else, and I encourage them to take small steps toward moving away from something like considering whether an issue is justiciable just on whether or not a state has consented to it, and let's take small steps toward a particular direction. The second thing I would say is like I think there is something powerful about legal reasoning in and of itself, and it's notable that even the powerful states, when they are forced to put down their reasons in legal language, it does have an effect of changing their behavior, if only slightly. So, again, I'm not suggesting that we're going to adopt a dignity-based account of international law and all of a sudden the system changes like radically overnight, but rather that appreciating that the current theory is inadequate. Let's move toward a theory that better captures the practice. And as states are compelled to provide their reasons in judicial forums, this in itself can be a catalyst toward moving something that is, in my more idealistic moments, it's better.
I don't disagree. I mean, I would point out. I think you need to have withdrawal kind of provisions. Thinking about where the technology moves beyond the treaty. So, for example, the Outer Space Treaty, which I don't want anybody to withdraw from right now, that it is in bad need of a rewrite.
Yeah.
And so, if you don't have that withdrawal process when technology moves beyond, or when you have a bad treaty. Sometimes you have bad treaties that just need to be withdrawn from, right?
So I'm not saying we shouldn't have the withdrawal process. I'm saying that the theory can't make sense of why the withdrawal process has to follow the terms of the withdrawal provision.
Because any law lays down predictive behavior, right? That's what we're looking for, right? We have stop signs because we want to predict who's going to stop at what corner, right? And I think that's why you know, and I know we're looking at this differently,
Yeah.
right? But you know, for me, legal systems are the creation of expected behavior. I can expect you to behave this way, right, when the situation occurs. And I will grant you, I think that becomes more problematic in terms of human rights. But the reason why we have stop signs, you know, do people follow stop signs? No, right? Not in my neighborhood, right? But at least it gives us a predictive about how other actors act. But thank you very much,
Thank you
guys.
so
Yeah,
much.
it's great.
Thank you for the comments.